You just got arrested for domestic violence. Now you're staring at a court date and you're trying to figure out how to get through this without spending a fortune. But here's the truth. Trying to save money now can end up costing you way more in the end. I see it happen every day. People wait, hoping that the case will go away. They think that they can't afford a lawyer until it's too late. And by the time that they realize their mistake, they've lost not only tens of thousands of dollars, but they've lost their job, their future, and their freedom. Let me show you exactly how this happens, and more importantly, how to stop it before it is too late. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a course called Defeat the DVRO, in which I teach you from start to finish how to represent yourself at a restraining order hearing and win. So if that is something that you need help with in addition to dealing with this criminal case, make sure that you get your free first class via the link down below. Okay, so let's jump right in. Today, we are going to break down the real cost of a domestic violence case and how the decisions that you make right now can seriously impact them through a case study. Meet John. John was arrested for felony domestic violence under Penal Code 273.5A. He never expected for this to happen, and like most people, he did not have $50,000 lying around for bail. So he put $5,000 on a credit card to a bail bondsman so that they could get him out of jail. But the financial nightmare was just beginning. While John is still in jail, the police serve him with an emergency protective order. That means that he cannot go home. He cannot contact the alleged victim. He can't even grab his stuff on his own. The police tell him that he can schedule a civil standby to pick up a few essentials, but that's it. Everything else is gone, at least for the time being. Meanwhile, he's still paying rent for an apartment that he can't live in. This is already a financial disaster, and his first court date is in a month. So what happens next? At this point, most people in John's position start thinking about hiring a lawyer. They know that they're facing serious charges. They know that they have a court date coming up. They know that they are already at least several $1,000s in the hole with their bail. But they start calling attorneys, and that is when reality hits. In California, most criminal defense attorneys charge flat fees, meaning that you know the total cost up front instead of being billed hourly. The idea of a flat fee is that it's based on how much work the attorney expects that your case will require. So the more complicated your case, the closer it is to trial, or the more damage that needs to be undone, the more that they are going to quote you. This is one of the reasons why hiring a lawyer early almost always costs less, even though it might sound counterintuitive. Now, one thing to keep in mind is that in addition to lawyers for criminal defense in California typically offering flat fees, many lawyers do offer payment plans, which can make hiring an attorney right away more manageable, but it is still going to be expensive, as John is going to see. So John starts calling lawyers. He expects that hiring one is going to be very expensive, but when he actually hears the cost, his stomach drops. Sticker shock. He panics and he thinks, look, I didn't do anything wrong. There's no way that they're going to convict me of this. Maybe I don't need a lawyer, or maybe I can just wait and see if I need one. When John's calling around, one of the law firms actually explains that a lawyer might be able to get the charges dropped before court, especially because John is calling right away. They explained that before the first court date, the DA still has to decide what to do with the case. And the police report is going to make him look guilty, but if they intervene, they might be able to stop the case before it even gets filed. That sounds pretty good to John, and he listens, he understands, but the price still scares him. So he hesitates. And then he waits. Now, in the meantime, he's stressed out. Every night he lies awake replaying the night in his head. He has no idea what's going to happen to him. Will the DA file charges? Will he lose his job? He hasn't heard from the alleged victim. He's not sure if he should reach out. So he decides to just wait until court to see what happens. He doesn't want to make anything worse. He has so many questions and he has nobody to answer them. His court date keeps creeping closer. He tells himself to stay calm. He's innocent. The system will figure it out. So he does nothing. Ultimately, almost by default, he decides that he's just going to go to court without an attorney. And that decision, as we will see, changes the course of his entire life. Let's talk about the next expense that can come up. After an arrest, the district attorney reviews the case and decides whether to file charges. If they do file charges, then at the first court date, they will ask for a criminal protective order, which will generally last until the case is over. This means that even if an emergency protective order, that initial protective order that's usually 5 to 10 days in length, is expired, now there's going to be a new restraining order put in place that lasts for the length of the case. And that can have significant financial implications, as John is about to find out. All right, so as we know, John didn't hire a lawyer before court, and the DA makes a decision, only having the police report to go on, which obviously looks terrible for John, since the police report is going to explain why the police felt that they should arrest him for felony domestic violence. So the DA files charges against John. And that means that even though the alleged victim isn't at court, nobody's heard from the alleged victim as far as we know, the DA asks the judge to put a criminal protective order in place, and the judge says yes. So now John still cannot go back home. He can't even contact his ex to find out what she's thinking. He's allowed to get some of his belongings via that civil standby, sure. But what about all of the furniture that he bought? His TV, his gaming setup, everything gone. The police are not going to stand there for the civil standby while you move. John estimates that his lost belongings were worth at least $5,000. Now, a domestic violence conviction comes with serious consequences, both criminal, which most people realize, and financial, which not a lot of people do. So let's break it down. If you are convicted of misdemeanor domestic violence, you face up to a year in jail. If you get probation, that will be for 3 years. The 3 years is mandatory. If you are convicted of felony domestic violence for the first time, you face up to 4 years in state prison. And if you get probation instead of prison, then it is a mandatory 5-year probation period. But even if you avoid jail or prison, a conviction comes with major financial costs that are easily tens of thousands of dollars. Here's what you could be ordered to pay. Criminal fines, up to $2,000 for a misdemeanor and up to $6,000 for a felony if it is your first time domestic violence case. A mandatory $500 fee is added to every domestic violence conviction. A donation to a battered women's shelter. Courts can require you to donate up to $5,000 as part of probation. There's also restitution. If the alleged victim claims financial losses, you could be ordered to pay things like medical bills, like ER visits, physical therapy, counseling, lost wages if they miss work due to the case. Property damage like phones, furniture, doors, electronics. Security upgrades. Some victims request thousands for cameras, alarms, or new locks, and sometimes the judge will make the defendant pay it. Restitution amounts vary case by case, but it's common for defendants to be ordered to pay thousands, sometimes tens of thousands of dollars on top of all of the other fines and fees. And there are also hidden costs, which unfortunately John will find out. So let's go back to John. Once charges are filed, John figured that he'd already paid enough. Bail, lost wages, housing costs. So he decided to stick with the public defender instead of hiring a private attorney. And at first, he feels okay about it. But as his court dates drag on, his stress keeps building. Every time he goes to court, he sees the DA getting more aggressive. At one point, he's reassigned a different attorney. Then one day, his public defender sits him down and says, "Look, I got you an offer. This is the best offer you're going to get. Plead no contest to felony domestic violence and take 5 years of probation. This is the best that they're going to offer you. It was difficult for me to get this in the first place. If you don't take this, your case will be set for trial. And if you're convicted after trial, you're facing up to 4 years in state prison." John panics because this is not how he thought that it was going to go. So he decides, you know what? Okay, I'm going to start calling private lawyers again. I know some people think, well, can't I just use the public defender at first and then hire a private lawyer later if I don't like the outcome? The answer is, well, you can, but it's going to be a lot more expensive. You're not going to save anything. And here's why. The longer that your case is open, the harder that it is to fix. By the time that you switch to a private lawyer, a few things might have happened. The DA may have already made decisions that hurt your case. Your lawyer might have said something that limits your defense. Evidence that could have helped you might be lost or unavailable, and the judge might have already ruled on key issues. All of that can make your defense an uphill battle. And this goes not just for using the public defender, but for using a private attorney who isn't doing a good job for you. If you switch attorneys in the case, at that point, the new lawyer has to undo any damage first as much as they can, which means more time, more effort, and more cost than if they had been involved from the very start. The first attorney that John calls tells him, look, your case has been open for too long. At this point, we would have to prepare for trial. That means witness interviews, court motions, and at least 2 weeks in court. So we would have to charge you a trial fee, and it's going to be very expensive. John keeps calling, but every attorney tells him basically the same thing. Instead of the lower pretrial quotes that he got initially before his case had actually gone to court, he was now hearing triple and even more the price that he was quoted initially. And he has no choice. He truly cannot possibly afford it. By the next court date, John realizes that his only option is to take the deal that the public defender had told him about. So before court, his public defender sits him down and explains the details of the deal. The DA is asking for the maximum fine of $6,000 plus a $5,000 donation to a battered women's shelter. You'll also have to complete 52 weeks of DV classes, and at some point, the victim may ask for something called restitution. John feels like he has no real choice. Every time he tries to push back about the cause, his PD tells him, look, you're avoiding prison, or this is the best offer that I could get you. It's either this or trial. The judge calls his case, John takes the plea, and he sits there feeling trapped as the judge sentences him to 5 years of felony probation, and he starts adding up all the fines and fees in his head. Okay, $6,000 fine, $500 domestic violence program fee, $5,000 donation to a battered women's shelter. Okay, at least I avoided prison, John tells himself, but he has no idea what's coming next. The next day, John goes to report to probation for his first meeting with his probation officer. That's when the probation officer tells him, you have to check in with me in person every single month for the next 5 years. John is stunned. Wait, what? Every month? During work hours? That's right, the officer says. We're open from 9 to 5, Monday through Friday. If you miss a meeting, that's a violation and you could end up going to prison. John works a full-time job and he really can't afford to miss work, but he has no choice. Each probation visit takes about 2 hours between travel, waiting, and the meeting itself. He makes $35 an hour at work. That means that he loses $70 per visit. And he types the number into his calculator and sees that over 5 years, he will lose $18,200. And that's assuming that he doesn't get a raise in that entire time. But there's nothing that he can do about it. John then goes to enroll in the 52 weeks of domestic violence classes. He's required to go to a court-approved program, and there's a list of limited places that he can go to. He starts calling the programs that are on the list, but there's a problem. Most classes are held during the day, but he works during the day. The only class that works with his schedule is an evening class that charges $75 per session. That's $3,900 over the course of the year. John thinks that the worst is over with. He's just going to comply with probation, bite the bullet, and hopefully move on with his life and pick up the pieces. But a few months into probation, he gets a notice in the mail. Mandatory court appearance, restitution hearing. Confused, he calls the public defender. The DA is requesting a restitution hearing, his lawyer explains. The victim is asking for nearly $20,000. John feels his stomach drop. What? I already took the deal. I thought this was over. Restitution is separate from the plea, his lawyer explains. The victim can request financial compensation for anything that she claims she lost because of this. John is furious. So we can fight this, right? His lawyer doesn't seem very hopeful and says, we can push back on some of it, but the judge is going to grant something. They almost always do. When he walks into the courtroom, the DA lays out a list of demands from the alleged victim. Moving expenses. She claims that she did not feel safe, so she had to relocate. Lost wages. She said that she missed work due to emotional distress. A security system. She wanted $14,000 for new locks, cameras, and an alarm system. John's lawyer argued against the security system, pointing out that it really has nothing to do with the case and is pretty excessive. The judge agreed, but still ordered John to pay $4,500 in restitution. He tells his attorney, I don't even have $4,500, but his attorney tells him, don't worry, you have 5 years to pay it off. As he left court, John felt completely drained. He'd already taken the plea. He'd already accepted the fines, the classes, and probation, and yet the system and his ex still found a way to take more from him. As he walks to his car, he tallies up how much this whole thing has cost and is going to cost him. We have the bail bonds for $5,000, lost property, $5,000, temporary housing costs after being kicked out, $3,000, court fines and fees, $11,500, restitution, $4,500, batterer's intervention program, $3,900, lost wages, attending probation, $18,200, for a total cost of $51,100 and counting. And now, John has a felony on his record. He can't pass background checks. He's disqualified from jobs in tech, finance, healthcare, any licensed profession, his career aspirations are basically dead. If he applies to a new job, the fact that he's a felon is going to come up on his background check. And he actually learns that even if he gets the case expunged, which he can't do until he's off probation, the felony will still show up on his background check. It will just say that it was reduced to a misdemeanor and then dismissed. But the felony's still there. It's not like it's deleted. And the worst part, he keeps replaying that moment in his head. The first time that he called an attorney and hesitated because of the cost. What if I had just hired them before court? Would my case have been dropped? Would I still have a job? Would I still have my future? If the case had gotten filed, would I have gotten a better deal? Maybe they could have gotten the $11,500 in fines and fees, or at least the $4,500 in restitution removed. But now it is too late for John, and that is the real cost of waiting. And I see it happen all the time. People assume that the case will go away. Some of the costs, like the bail bond, okay, you can't do anything about at this point. But if John had called a lawyer early on, he really may have avoided all of this. And it might have actually ended up being a lot less expensive and a lot less painful. Last year, 75% of my clients had their cases dismissed before ever stepping into court, and over 95% avoided a conviction entirely, even when their cases got filed. But that only happened because they acted early and because we were very proactive. When I check on people who decided to wait, or when they call me later on after they are already in John's position, I see the same pattern over and over again. The DA files charges and suddenly they're in a much worse position. And look, I would never tell someone in John's position, I told you so, right? You don't want to rub salt in the wound or make someone feel bad. But what I do want is to prevent people from being in that position. You have one shot to handle this the right way. If you wait, it only gets worse. It gets more expensive, harder to fight. And once the DA files charges, there is no undo button. Don't make the same mistake that John did. If you call a lawyer now, you could stop this before it ruins your life. I hope that this video helped you. And more than anything, I hope that if you were thinking I'm just going to wait or it's impossible or I'll just see what happens, I really hope that this was a wake-up call. Call an attorney, book a consultation. It does not have to be with me, although the link is right there down below, but you really need to take action early on. This is your life. You only get one.